My great people, I have a bone to chew with you. The U.S. Citizenship and Immigration Services released a policy memorandum with the following subject. Adjustment of status is a matter of discretion and administrative grace, and an extraordinary relief that permits applicants to dispense with the ordinary consular visa process. Now, the whole purpose of this whole memorandum is here. This memorandum reminds officers and the public that adjustment of status under Section 245 of the Immigration and Nationality Act, that is INA, is a matter of discretion and administrative grace, not designed to supersede the regular consular processing of immigrant visas. U.S. Citizenship and the Immigration Services, that is the USCIS, reaffirms this consistent and long-standing approach and declares as a matter of general policy its intention to faithfully apply the statutes consistently with this understanding. That is the whole purpose of this policy memorandum. Now let's go to the background analysis of this whole memorandum. It says that it has been long established that not every alien who meets all other eligibility for adjustment of status will be granted adjustment, because adjustment under most provisions is granted only as a matter of discretion and administrative grace. Bombshell. Now, another thing that I picked and highlighted in the background analysis is the Supreme Court has consistently and routinely stated that adjustment of status is a matter of grace. Now, I want you to think about that, ponder it in your mind, and what do you think about that? Is it really a matter of grace? Nevertheless, let's get to page 2 of the whole document. Now, to pick it from page 1, I connected, it says that the lower courts likewise describe adjustment in terms of being an extraordinary act of administrative grace. Courts repeatedly describe adjustment as extraordinary relief. The nature of adjustment of status relief remains best understood as extraordinary because it permits the alien applicant to avoid the prescribed ordinary consular visa process to obtain lawful permanent residence without leaving the United States. What do you think? What's your opinion over this whole matter? Now, that aside, I want to take you to something that was very, 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 very critical. Let me go with you to page 3. It says, Congress established significant limitations of the eligibility of aliens to adjust status that do not apply to aliens seeking immigrant visas and admission from outside of the United States. Most aliens seek discretionary adjustment of status under Section 245A, as I showed you in page 1 of the INA, which states that their status may be adjusted by the Secretary in his discretion. If they are present in the United States after having been inspected and admitted or paroled into this country and are admissible to the United States for permanent residence, among other requirements. Now, as a result, aliens physically present in the United States who have not been inspected or either admitted or paroled are generally ineligible to adjust status. Think about that. Where is this heading? Who will it affect? And who and which group is in turmoil as we are talking? Now, let me get you to something under page 4. It is very interesting and very, very key. It says that with limited exceptions, now I want you to get this clear. With limited exceptions, the statutory scheme suggests that Congress expects aliens paroled into the United States or admitted into the United States as non-immigrants to depart rather than pursue adjustment of status. Such aliens are generally expected to pursue an immigrant visa and admission from outside the United States if they wish to reside permanently in this country. Get to your country, adjust the status from there. Who are in turmoil? Who are in this havoc? Who is in this hurdle? Think about that. Now, let me take you to something also that is very key about the guidance that is in page 5. The guidance part says that where adjustment of status is in discretion of the USCIS, officers are reminded that they are to consider all relevant factors and information in the totality of the circumstances in exercising that discretion. For example, existing guidance directs officers to consider violations of our immigration laws or the conditions of any immigration status held. Now, the big part of this whole thing, I want you to read and understand this. As I read, as we downscale to this whole document, read and understand it properly, chew it, and understand the whole memorandum. It's very, very important for you and for the rest of the other nations. Now, let's go. This point is very key. I want you to understand. Let me pick from this part that this is particularly true when the failure is connected to the alien's intention to reside permanently in the United States, and the alien could have achieved that goal through normal immigration visa process. USCIS reminds its officers that applying for adjustment of this status is not inconsistent with simultaneously maintaining non-immigrant status in a category with dual intent. Couples, how are you? Right, now let me go. Another thing, USCIS reminds its officers that they must consider and weigh all the relevant evidence in the record, taking it into account the totality of the circumstances to determine whether the alien is suitable for permanent residence and if approval of the alien's adjustment of status application is in the best interest of the United States. Adjudicators must weigh all positive and the negative factors, including family. And not only family, but family ties. Now let me take you to the last part that is very, very important and very critical. Now, in page 6, I want us to pick a part here that says, USCIS reminds officers that when they deny a benefit request, they must issue a denial notice, explaining in writing the specific reasons for denial. When the denial is based on an unfavorable exercise of discretion, the denial notice must include an analysis containing the positive and negative factors considered, along with an explanation of why the negative factors outweigh the positive factors in the decision. You get it? So they must also explain as to why that denial or that factor, whether positive or negative, whether acceptance or rejection, is being considered. Right, another thing is here that now USCIS may provide policy guidance specific with certain adjustment of status categories or discrete populations of aliens to aid officers in identifying those applications that may or may not warrant this act of grace and exception to the regular consular process. Now, this is now the key thing: use. Let's go. Use. This policy memorandum is intended solely for the guidance of the USCIS personnel in the performance of their official duties. But it does not remove their discretion in making adjudicatory decisions. My good people, that is the information in the whole document, and I humbly beseech and urge you to go through the document, read, understand, and pick something and have the whole gist of what the document says. Before writing any comment, read the whole document. I'll attach it. I've even showed you that document. What's your take? What's your opinion? Before I leave you, I want to show you some of the tweets and some of the affected parties or the affected individuals are writing in the tweet. Now, I went to the home of Twitter. I went to Twitter and directly dived myself in the page of the U.S. Citizenship and the Immigration Services. That is their Twitter page, and currently they are following 333 people, and they have 562.9k followers. Now, in that page, they posted the same tweet. They said, "We are returning to the original intent of the law to ensure aliens navigate our nation's immigration system properly. From now on, an alien who is in the US temporarily and wants a green card must return to their home country to apply except in extraordinary circumstances. These policies allow our immigration system to function as the law intended instead of incentivizing what we call loopholes. When aliens apply from their home country, it reduces the need to find and remove those who decided to slip into the shadows and remain in the US illegally after being denied residency." That is the USCIS spokesperson, Zach Kalha. Now, that is what they posted, and currently it has 4 million views, 3k likes, 1.1k reposts, and 468 comments. Among the tweets, I have Richard Solomon, who is saying, "Spouses, parents, and siblings of the US citizens who are already here legally, or people who are already working in the US legally, should not have to move abroad just to flagpole and wait years, while Miller and Rubio cook up another reason to single out non-whites." That is his opinion. Another opinion is from JMUS. He says, This is nothing but a way to get employment-based green cards. Everyone knows once you leave the country, you can't work from overseas, and your employment visa is therefore invalid. So even if you applied for a green card based on your employment, you won't be eligible anymore because the employment visa doesn't exist anymore. That is his opinion. Another opinion we have, Michael Marias has this tweet. There's a difference between protecting the integrity of the immigration system and treating every immigrant as if they are abusing it. Not everyone on a green card is hiding in the shadows. Many people currently in the US under temporary visas, work permits, pending adjustments, or approved immigration cases are here legally, working, paying taxes, raising families, and contributing to the society every single day. Yes, every country has the right to enforce immigration laws and remove criminals. But there are also thousands of people stuck in months-long USCIS backlogs who did things the legal way and are still waiting on a system that moves painfully slow. This conversation should both include border security and fairness for people who are already contributing positively to this country. Migration enforcement and humanity should not cancel each other out. Andrew Ng says, the new White House policy requiring green card applicants to apply from outside the US is a capricious attack on the legal immigration. It will hurt families, leave us with fewer doctors, teachers, and scientists, and hurt America's competitiveness in AI. All right, those are some and few of, the tweets that I picked. And you'll go to the portal, you'll go to the house of Twitter, as I call it, of the USCIS, and look into it, look more on what people are saying. Now, I have something to tell you. From all that policy and memorandum, what is your take?